That's a lot of time. If you don't change your ways, it's not going to go well for you in this world. Do you both counts you're charged with aggravated assault? The range of punishment in each of those cause numbers is anywhere from 5 to 99 years or life in prison. Did you understand? It's calling 2023 CR 2703, 2023 CR 2704, and 2023 CR 2530. State of Texas versus Tyrone Eds. Is it Eds or Eats? Eats. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
For the defense.
And are you Mr. Eats?
Yes, ma'am.
Counsel, have you received all the discovery in each cause number, and did you review that discovery with your client?
We have, Your Honor.
And each cause number, the court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Eads, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
State, and cause number ending in 2703, are you proceeding on the indictment as presented?
Yes, Judge.
And in cause number ending in 2704, are you proceeding on the indictment as presented?
Yes, Judge.
And in the cause number ending in 2530, are you proceeding on the indictment as presented?
Judge, just one moment. There was no notes on the file itself.
All right, just 1 minute. I'll be able to tell you.
Thank you, Judge. Sorry about that.
That's okay. Yep, there are 2 counts.
Oh, does it say on there, Judge? Yeah, it doesn't say on there, Judge.
No.
Oh, I was proceeding on those.
Oh, okay. Okay, sitting as presented, Judge.
All right. And each cause number ending in 2703 and 2704, you're charged with aggravated robbery. And in each cause number ending in 2530, and both counts, you're charged with aggravated sexual assault. The range of punishment in each of those cause numbers is anywhere from 5 to 99 years or life in prison. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, ma'am.
Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of these cause number?
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Eads, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the pleas? Anyone promised you anything other than the pleas?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the causes are to run concurrently. State is going to be taken in consideration 2023 CR 2702, 2023 CR 2705, and cause numbers ending in 2703 and 2704. If the court determines there's an affirmative finding of deadly weapon, then the court will enter an affirmative finding of deadly weapon. And that is the same in cause number 2530. And according to the plea bargain agreement, the punishment is to be assessed at 30 years in the prison. Did you understand that to be the plea in each of the cause number?
Yes, ma'am.
Defense? State?
Yes, Judge.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions? Then in cause number ending in 2703, how do you plead? Guilty, not guilty, or no contest?
Contest.
And the cause number ending in 2704, how do you plead? Guilty, not guilty, or no contest? And in cause number ending in 2530, how do you plead? Not guilty? Guilty or no contest? State any evidence.
Honor state would offer states civil one each of the separate cause numbers.
We had a chance to review, Your Honor, no objections.
In each of the cause numbers, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Again, in each cause number, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, but most importantly, there will be no live witnesses? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments in each cause number, and the court will review the same. All right. In each cause number, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we would ask the court go along with the plea bargain as it has been tendered by the state. My client is taking full responsibility of the matter. My understanding is he even has written a letter of apology in the sexual assault case. And so we would ask you to give him credit for all the time served and give him the plea bargain amount.
All right. And the cause number ending in 2703, the court will find you guilty. The court will find there's an affirmative finding of a deadly weapon. There's to be no contact with Daniel, Laura, and John Albert Elizondo. This will run concurrent with 2023 CR 2704, 2023 CR 2530. Take in consideration 2023 CR 2702 and 2023 CR 2705. Is there anything else with regards to sentencing in that case? And the cause number ending in 2704, court is finding you guilty. Court is finding an affirmative finding of deadly weapon. There's to be no contact with Daniel, Laura, and John Albert Elizondo. Court will sentence you to 30 years in the prison. And I'm sorry, and the cause number ending in 2703, in case I didn't say it, the court has sentenced you to 30 years in the prison and give you credit for any time served. And back in cause number 2, ending in 2704, court is going to sentence you to 30 years in the prison, give you credit for any time served. And this is to be concurrent with 2023 CR 2703, 2530, taking consideration 2023 CR 2705 and 2702. Is there anything with regards to sentencing under that cause number?
No, Your Honor.
And then in cause number ending in 2530, your plea of no contest was to both counts 1 and 2. Is that correct?
Yes, Your Honor.
Then the court will find you guilty in count 1 and count 2. Count 1 and count 2 is to run concurrently. Court will sentence you to 30 years in the prison, give you credit for any time served. There's to be no contact with the complainant. This is to run concurrent with 2023 CR 2704, 2023 CR 2703. There's an affirmative finding of a deadly weapon. Taking consideration 2023 CR 2705, 2023 CR 2702. There's to be Chapter 62 compliance. Is there anything else with regards to sentencing in that cause number?
No, Your Honor.
And each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney. Did you understand it and did you sign it?
Yes, Your Honor.
Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapon or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
21.
All right, so 30 years, that's a lot of time. But do not go to the prison and become institutionalized. Eventually, you'll be released from prison. And if you don't change your ways, it's not going to go well for you in this world. Do you understand?
Yes, Your Honor.
All right, good luck to you. Oh, do you want a jury trial? Improperly, you were going against traffic, which means other people could have been injured. In the vehicle, you had an 8-year-old and a 10-year-old. I advised her that I would have a female officer to make the location, and she walked away to a tree and started to urinate. After she finished urinating, I completed the interview. She had bloodshot, glassy eyes, slurred speech, and was unsteady on her feet by consuming any alcohol, and also denied that she first admitted to consuming alcohol. She did not know what time it. Did you understand the state is proceeding on the lesser included offense of driving while intoxicated first as a Class B misdemeanor? The range of punishment is up to 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand? All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing? Anything you wish to say on behalf of your client?
With respect to the recommendations by the DA with the 2-year license suspension, my client cleans houses for a living. He needs to be able to drive. He does take children to school, for children and school activities and so forth. So I'm asking the court for some leniency on the.
Oh, no, her license is going to be suspended. Did you read this police report?
Yeah, I don't think it was.
Oh, do you want a jury trial? Because let me just tell you what I read in this police report.
I know, I've read.
Now, let me tell you what it is, because I don't think you have internalized what's in this police report. So you had your children with you. And according to this, you were pulled over because you were driving against traffic. So that means that you were driving improperly. You were going against traffic, which means other people could have been injured. In the vehicle, you had an 8-year-old and a 10-year-old. And it says, when I arrived on location, AP, that's you, was standing on the sidewalk, unhandcuffed. I had her walk to the front of my patrol car. She said she did not know why she was stopped, but supposedly she was going against traffic. AP then admitted to consuming 2 drinks at Ingram Park Mall at a bar, but did not know the name of the bar. She started drinking at 8 p.m. and stopped at 9 p.m. AP later denied consuming any alcohol and also denied that she first admitted to consuming alcohol. She did not know what time it was. She said she was not driving. She was shopping. Last date at 3 p.m. And is not under a doctor's care and has no prescribed medications. During the interview, she said she needed to use the bathroom. So I advised her that I would have a female officer to make the location, and she walked away to a tree and started to urinate. After she finished urinating, I completed the interview. She had bloodshot, glassy eyes, slurred speech, and was unsteady on her feet. The odor of alcohol was also getting stronger as she kept talking. They did the HGN. You failed the HGN. So I am not sympathetic to her with the driver's license suspension. Her license is going to be suspended. Do you realize you could have killed your children and other people?
Yes,
But do you understand that?
I haven't drank since. Yes, I very understand
When's the last time you had alcohol?
that day.
All right, when you drug tested today, what are the results going to be for everything?
Forever.
All right. Probation, I'm going to want a drug test on Miss Ledesma. And I'm going to also want it for alcohol if you're able to do it for alcohol as well. Are you employed? You're cleaning houses?
Yes.
All right. And how often do you do that?
Almost every day.
Do you work with the company or no?
No, for myself.
So how are you paid?
Oh, with my customers.
I mean, is it payment by check, cash?
Oh, yeah, Zelle, cash sometimes.
Okay.
She works for an attorney friend of mine that's representing.
Okay.
Work for.
All right, you're whispering so the court reporter can't hear.
Say, she does work for various people and she gets paid cash or check. And she things happens for other attorneys that I know that I got involved.
Were you able to hear him? Okay. All right, the court is finding you guilty. The court is going to sentence you to 180 days in the Bexar County Jail, suspended and probated for 2 years. There's a $2,000 fine that will be probated. Do you know the restitution amount for the labs?
It's usually $60, Judge. I'm not sure if it is in this case.
All right, restitution for lab testing, if any. I'm going to want a TAP evaluation. Follow recommendations of TAP. If they say outpatient treatment, then I'm going to want intensive outpatient treatment. I'm going to want 90 sober meetings in 90 days. Proof of employment within 30 days. There's to be no employment as a home health care provider with minors.
We want to get her started off on the right foot. That's why we're only requesting it within the first 60 days. Ignition interlock, we're requesting for half the term of probation, which would obviously be longer than that. So we want to keep her monitoring, and I believe it may be required by statute.
No, I mean, the ignition interlock, yes, but I mean, ignition interlock in Scram is going to be very expensive.
That's good. Please.
You're going to have ignition interlock on every vehicle that you have access to. And when I say have access to, if it's parked at your house, if it's owned by your husband or whoever lives at your home, ignition interlock is going to be on there. And that's going to be ignition interlock for the full term. 2-year Texas driver's license suspension. And I'm going to want regular UAs, field visits, 1 time per month. And please tell probation, check her home for alcoholic beverages. When you're on probation, you're not allowed to drink alcohol at all, even in your own home. You understand? And there's to be regular reporting by Zoom or in person. Probation, is there anything else? Anything else you need from the court? Good luck to you. We can go off the record. Here's the thing. I haven't done any statistics. My statistics professor would be very upset with me for this. But what I've learned is people who drive intoxicated, if there's an accident, you know who ends up dying? Passengers in the vehicle, other people who are just going about their business. Probably your children could have been killed that day. And then if they would have been killed that day, you would be in court boo-hooing and crying about my children are dead. So, yes. So you shouldn't have started. All right, probation will go over conditions with you.
Thank you, Your Honor.
Yes.
At just 21 years old, Tyrone Eats stood before a Texas courtroom facing charges that would change the rest of his life. Prosecutors accused him of committing 2 aggravated robberies and 2 counts of aggravated sexual assault, some of the most serious felony offenses under Texas law. Each charge carried a possible sentence of 5 years to life in prison. After reviewing the evidence with his attorney, Eats chose to accept a plea agreement. He pleaded guilty to the aggravated robbery charges and entered a no-contest plea to both counts of aggravated sexual assault. The agreement called for a 30-year prison sentence, with all of the cases running concurrently, meaning he will serve the sentences at the same time instead of one after another. During the hearing, the judge carefully explained the constitutional rights Eats was giving up, including his right to a jury trial, the right to confront witnesses, and the right to remain silent. She also confirmed that his plea was made voluntarily and that he understood the consequences of his decision. The court reviewed the prosecution's evidence, found it sufficient to support the convictions, and formally found Eats guilty on every count. The judge also entered an affirmative deadly weapon finding, making the convictions even more serious. In addition to the prison sentence, the court ordered no contact with the victims, required compliance with Texas sex offender registration laws, and informed Eats that, as a convicted felon, he would permanently lose the right to possess firearms or ammunition. Before ending the hearing, the judge addressed the young defendant directly. She reminded him that 30 years is an enormous amount of time and warned him not to become institutionalized while in prison. She told him that one day he would likely return to society, but unless he changed the course of his life, his future would remain bleak. It was a brief but powerful reminder that accountability does not end with sentencing, and rehabilitation is ultimately a personal choice.